Welcome to Conozca sus derechos, Know Your Rights. This program is brought to you by the Hispanic Bar Association of Central Florida. It is our mission to inform our community of important legal topics affecting us all. And today, we will continue our discussion regarding immigration issues. I'm Henry Lim, the Community Relations Chair of the Hispanic Bar Association of Central Florida. Today, we will discuss various topics relating to immigration law. We will be discussing common mistakes and misconceptions surrounding these issues. During our program, we will hear from various professionals in our community who are quite knowledgeable in the area of immigration law. Let's begin by introducing Attorney Jorge Sevilla. Jorge, how are you today?
Hi, how you doing?
Good. Tell us a little bit about yourself.
Well, I'm a Miami native. I went to Florida International University for undergraduate school and also college law studies. And I decided to become an immigration attorney because of my background. And I'm really interested in helping the immigrant community here in the Orlando area.
Very good. Welcome to our program today, and thank you for participating. And also with us today is Melissa McGuire-Banyao. How are you, Melissa?
Good. How are you?
Good. Tell me a little bit about yourself.
Well, I was born in Puerto Rico, raised here in Central Florida. I'm a senior at Rollins College, and I serve right now the immigrant community through the Florida Immigrant Coalition as the Vice President of the Board of Directors.
Very good. Welcome to the program. And we'll get right to it. We're talking about immigration. It's a hot topic everywhere you turn in the news. Just about every day you'll hear something dealing with immigration. Mm-hmm. What are some of the hot topics that we've seen in the last couple of years? Jorge?
A lot of the hot topics are mainly this year was the unaccompanied minors coming through our borders. That's a very hot topic right now. The court system's trying to determine how they're going to treat these cases. Also, the immigration officials are trying to decide what they're going to do with these poor children coming through these borders.
Now, do these children oftentimes have family or not in the U.S.?
Sometimes they do, but the majority of them do not. So the issue is trying to find homes for these children and how they're going to be represented throughout this process. Because if the immigration process by itself is scary for adults, just imagine a child, a minor, not knowing the language in this country is very, very difficult for them to understand, and being unrepresented adds to that difficulty.
Many people in the U.S. are not that familiar with what the inner workings of immigration law. Many people have opinions about what should happen with immigration law. Let's try to clarify today some of these issues. For immigration purposes, who can petition for someone to reside in the United States? What are the allowed family relationships? For example, can my cousin petition for me if I needed immigration help?
No, unfortunately, your cousin cannot. It's limited to immediate family members a lot of the times. Either it's going to be a U.S. citizen parent, spouse, or child can also, or daughter or son that can petition for people. As for lawful permanent residents, it could be also a parent, a spouse, and in certain cases, siblings.
Okay. And how long does it take to obtain permanent residency through these categories? Depending
on the category that you fall under, depending on the country that you're from, it can take anywhere from 20 years to maybe a year and a half from now.
Okay. And Melissa, one of the things that we hear oftentimes in the context of comprehensive immigration reform is you need to get to the back of the line. Mm-hmm. What line are these people referring to?
There is a very long waiting period. He referred to 20 years. In a personal situation in my family with my husband, his mom petitioned for him in 1997. It was approved in 1998. And part of that petition was the declaration that mom was providing for the kids, which were now adults, and so it was disclosed that they were in the country, and the government said, to stay put and wait for your turn. And so that turn is 15 plus years. And so essentially you have some folks that are undocumented that have nothing pending, and you have folks that do have something pending. And so the conversation is around, well, who goes first, and how are we going to process this volume of applications? And so the compromise is to have the folks that are pending addressed first and in a more permanent fashion, so they would process them before the undocumented folks. They would be able to identify themselves, but their process would be pending before those folks that are already in the process get processed first.
For some of these applications that are pending for, say, 20 years, are they all 20 years?
Not all of them.
Is the waiting line 20 years for everyone?
No, not for everyone. Certain countries fall under 20 years, but also certain relationships it may affect. Let's say, for example, I have a client who came in and his mother petitioned for him as back in the 90s, but now he changed status because he went over the age of 21. And for immigration purposes, a child is considered somebody under the age, a minor under the age of 21 who is unmarried. But let's say he got married or he went over the age of 21. Well, now he falls into a different category. So that, depending on the quota system at the time, there's something called the visa bulletin, and that's where it lets everybody know what date they fall under. It could be the 20 years, or it can be a little less than that, or more, depending on the specific category.
Okay, well, during these times that the process is pending, say 20 years, 10 years, 5 years, whatever it may be, can the person who's being petitioned for remain in the U.S.? Do they get any sort of legal status?
No, they do not. An immigrant visa petition does not give you status, but in limited cases, based on law that was passed in the year 2000, you can become 245I eligible. Meaning, in cases like Melissa, where her brother, her husband was petitioned for prior to a certain period, that petition is held. So let's say like Melissa files for her husband now, or like she did, that priority date, as it's known, that date from that prior petition is preserved, even though he was here in the United States. The thing is, you have to find somebody to petition for you afterwards.
And what other topics have you seen in recent years as far as any sort of changes with immigration law? What is the issue with the 3 and a 10-year bar, things that I've heard of that nature?
One process that has come up is the Provisional Waiver. Before, when a person was barred either under the 3-year bar or the 10-year bar because they stayed beyond the 6 months or the year period, what would happen now is that they're able to apply here in the United States. So, for example, you have somebody that came in without inspection. I had a client come in the other day. He told me he came in without inspection, and now he married a U.S. citizen spouse. Well, there's this process now where his wife is able to file the petition for him, but instead of having him to go to the consulate and wait for the interview and then file for the waiver, he's able to file for the waiver here. And his spouse has to prove that she's going to suffer extreme hardship by him either having to return to his home country and she has to remain here by herself, or showing that she's going to suffer hardship, extreme hardship, by having to go to his home country with him.
Well, that same example that you gave us, the husband entered without inspection in the United States. That means that he just crossed the border, right? That means he had
Typically,
no
yes,
visa
that's
to
what
enter the
happened.
U.S. That's
Yes.
what that means. What if that person would have entered with a visa and, let's say, just overstayed his allowed time in the U.S.? Would that person need a provisional waiver?
No, in that case, if the person's married to the U.S. citizen spouse, they would not need a provisional waiver because they'll be able to file for an adjustment of status here in the United States.
The only difference between the two is that he entered with a visa?
The thing is, when you enter with a visa, you are admitted by the customs officer. You are admitted by immigration to come into the country. Now, if you overstay, that is a violation of immigration law. But the key to adjustment of status to become a resident here in the United States is being admitted being admitted at entry. So if you come without inspection, you were never admitted, and that's why you have to go through the other route of the consulate processing and filing for the waiver.
Well, same example, the person entered with a visa, a tourist visa to come in and see the parks and things of that nature, decides to overstay, and now instead of getting married to a U.S. citizen, let's say that they have a brother or a sister who's a U.S. citizen, can that person wait in the U.S. because they entered lawfully into the U.S.?
Could that person wait in the U.S.?
Because we said it would take about 20 years, right? Mm-hmm. What happens in that case?
No, in that case, he cannot because he's acquiring unlawful presence and there's no visa immediately available. In the other case, with a husband married to the U.S. citizen spouse, the visa becomes available. But now, in this case scenario with the siblings, he's back into the quota system. He's back into that visa bulletin So he doesn't have a lawful status at all throughout that period. So it's going to affect him.
I think the lesson of this is that just because it applies to one case does not mean it's going to apply to the next.
People have to be very careful when they listen to their friends or family. It's always good intention, with good intention, but every case is different. Every case that comes to us is different, and the circumstances that benefit one person may not benefit the other person, and it actually may hurt them. So people have to be very careful with that.
And what happens with situations such as notarios who try to offer help to these individuals?
Be very cautious. I understand that it may be a little less expensive than seeing an attorney, but a lot of times these people are not experts, or they don't have the knowledge. A lot of times they just help file the form, and at the end of the day, they don't really know why or how the benefit is conferred by the government. So it may lead to more issues down the road. So I heed extreme caution in those type of cases.
Have you seen any situations with notarios in what you do?
Absolutely, yes. I mean, what starts out being a savings ends up costing you a lot more in the long run, and not just money, in separation and a lot of grief with the family, because to repair those mistakes is very difficult, if not impossible in some cases. And so I caution folks to make sure that that they're dealing with licensed professionals that are experts in immigration law, to protect themselves from that happening. That happened in my family's case. That's what ended up causing my husband to get an order of deportation, and it took us as a married couple 8 years to undo that. And in totality, he spent 28 years in an undocumented status. But in his family, his brother and his sister ended up being deported as a direct result of mishandling their cases by quote unquote experts, which were really just notarios. And so they're not as well versed in immigration law, and they could, even with good intentions, be filing the wrong documents, and it's just a bad idea.
Great. Well, thank you so much for your input. It's time for a short break. Please stay tuned as we discuss other topics in immigration legal matters. We'll be right back. Welcome back to Conozca sus Derechos, Know Your Rights, programming brought to you by the Hispanic Bar Association of Central Florida. I'm Henry Lim, Community Relations Chair of the Hispanic Bar Association of Central Florida. And with us today to discuss immigration legal matters are Melissa McGuire-Mignao and attorney Jorge Sevilla. Welcome back.
Thanks.
I'd like to talk a little bit about citizenship now, because it's a very important topic. It's near and dear. We're all living in the United States. If you're a permanent resident, why should you become a U.S. citizen?
Because remaining an illegal permanent resident status is not a guaranteed status. So there is a risk that if you're at the wrong place at the wrong time, that status can be revoked.
But they call it permanent residence.
Yes, it's permanent residence, so long as you don't do anything that the government deems to be grounds for to revoke that status. And so it does happen. Legal permanent residents, if you travel to certain countries, get scrutinized more at the airports, and you could be denied re-entry into the country. There's a whole host of things that could happen. There's risks, essentially. And so you want to just be fully aware that that's there. And so to eliminate those risks, once you complete your 3 years, if you got it through marriage, or 5 years through another avenue, file for citizenship. There's many ways to do it. Right now, there's waivers for certain people that qualify if you're able to show an inability to pay. And in Central Florida, we have approximately 95,000 legal permanent residents that are eligible to become naturalized right now.
And what is the main reason why they do not file for citizenship?
Lack of information or misinformation, language barriers, but general, or cost. but it's usually more often than not misinformation. They think it's a very long process, when on average it's really 4 to 5 months. It's really not as cumbersome. If there's lots of help in the community to learn to prepare for the citizenship test. So and you get the right to vote, and I think that that's really, really important to be fully integrated and be a part of democracy. You live here, you work here. I think folks should have a say in their local elections, state and federal, and so. There's lots of benefits to being a citizen, absolutely.
And what does one have to do to apply for citizenship? How does one become eligible?
To become eligible for citizenship, typically a person has to be a lawful permanent resident for 5 years. If they're married to a U.S. citizen spouse, it'll be 3 years. And then there's also the requirement to take the examination, which would be in English. In limited circumstances, it could be in the native language of the person. But the key is to know it's a civics test. Pretty much, you got to know the civics test. You got to have good moral character within the statutory period, which is a 5-year period prior to applying for citizenship. So people have to be very careful. If you have something that may concern you, your record, maybe you haven't paid your taxes, or you have some offenses that you were convicted of that you're worried about, then you may want to consult an attorney to make sure whether that's going to affect you, or maybe you should delay your filing of filing for citizenship.
And I've heard something about selective service. Can you explain to us what selective service means, and how does that affect a citizenship process?
Well, for selective service, every male person every male person here in the United States has to file or register with the selective service. It's part of the U.S. Armed Forces. That's if they're in need of a draft, they would go into the selective service, and that would make the person eligible to be part of the military. So yes, there would be a requirement for you to be, if you're a citizen, that you would have to become part of the selective service.
But the registration procedure has a limited time, correct? I mean, you can only do it during certain ages.
Right, I believe it begins at 18. I'm not sure where the cap is at.
And what happens if someone does not register for selective service? How can that affect a citizenship application?
It could possibly end up in denial. You could probably get a denial of your citizenship at that point in time.
Okay. And are there any ways to obtain citizenship without knowing English?
Usually it's aged, right? There's a cap. Not sure what the age limit is, but if you're over a certain age, you're not required to meet that requirement. 55?
The 50-20. There are 3 of them. If you're over the age of 50 and you've been a lawful permanent resident for 20 years, you may be eligible to take the examination in another language. Also, I think it's 55.
There's also
disability as
waivers.
well. Disability waivers. But with the age requirements, it's 55, 15 if you've been a lawful permanent resident for 15 years and you're over the age of 55, and also a 65-20 age requirement. And then, yes, we've had a client before where the person was experiencing some retention issues, memory retention, so he couldn't really memorize the civics questions. So in that case, we filed for a medical waiver. We had a doctor write up a waiver and write up a diagnosis of what his condition was, and they were able to grant him citizenship without having to do the examination at that point.
I worked a clinic a couple weekends ago, and there was a gentleman that had suffered a stroke, and he had been a legal permanent resident for over 20 years.
Wow.
And he was able to apply for citizenship.
Because the stroke impaired his ability to learn English?
And he was able to get a waiver for the testing and for the language piece of it. And because of the stroke, he was on disability and was able to qualify for the fee waiver as well. So it was a win-win for him.
Very good. And another topic that I've heard about is the 10-year law. I hear many people say if you've been here 10 years, then you get a green card. How does that work?
It's a misconception. It's a grave misconception. We have a lot of clients coming in from all types of nationalities saying, "Oh, well, I've been here 10 years in this country, so what can we do now?" And the thing is, for this law to apply, what they're referring to is what's known as cancellation of removal. And at this point in time, you would have to be in removal proceedings for you to apply for cancellation of removal.
So in order to apply, you have to be in danger of removal already?
Correct. You have to you'll be in removal proceedings, and one of those requirements is have been here for 10 years, a continuous presence in the United States for 10 years. But the harder part of that law, or the stringent requirements, are that you show exceptional and extreme hardship to either a U.S. citizen, spouse, parent, or child.
And what does that mean?
What it means is that it's very limited. And I believe in the nation, there's only 5,000 cases per year that are approved. And we're talking about numerous immigration courts and numerous removal proceedings cases. So it's very limited, and you have to show what's beyond the normal suffering between a separation or somebody getting removed from the country. And it's not just beyond the normal, but above that, because it's exceptional and extreme hardship. So you would have to show that the person that's qualifying would have to have some type of medical hardship, physical hardship, psychological or financial, or beyond that. So it's very limited cases. So I wouldn't recommend anybody, just because they've been here for 10 years, to go seek to be placed in removal proceedings to try and attempt to file for cancellation. It's not advisable at that, just because you've been here for 10 years.
Now, in Central Florida, we have many, many tourists who visit us, and many of them may be watching the program today. Sometimes these tourists decide, I want to stay here a little bit longer. What should a tourist do in order to not jeopardize their ability to either remain or return to the United States if they choose to stay here longer? Are there any avenues, anything legally that they can do?
They can file for an extension of status, but the key is to file an extension of status prior to their status terminating. So if they've been granted 3 months, they may want to file for an extension within the 2-month period, within 2 months of being here. The 6 months, they may want to file prior to this, within 4 months of being here, to see if they'll get that extension granted. Now, what they have to be careful of is if they've been in the country previously and they've been here for 6 months or a year, normally we advise those clients they would have to be outside of the country for that same amount of time, because their time here would be limited every time they file for an extension or they're coming in and out of the country. So that's what we would advise clients to do.
And what would someone need if they were looking to obtain an extension of their status? What would they need to bring to you to get another 2 months, 3 months to be able to stay in the United States without risking what you mentioned before was called unlawful presence?
Right.
What type of documents do you look for?
We typically ask them to bring itinerary or a plane ticket showing that they're going to depart, that they have the financial means of supporting themselves, such as bank statements from their home country, and also maybe a letter explaining why is it that they want the extension, whether it's to visit family members, visit our landmarks here in the United States. So those are the typical documents we would want a client to have.
And what if someone decides, you know what, I don't want to file for an extension, I just want to stay here for another couple of months? What risks are these people running?
Again, they would run the risk of overstaying and the risk of those 3 or 10-year bars. If they stay beyond the 6-month period, they're going to be facing the 3-year bar. And if they stay beyond the year, they'll be facing a 10-year bar. And it would be quite difficult once they leave the country to come back in.
What would they have to do to try to come back in?
It depends. If a family member has petitioned for them, they would have to file for the waiver that we spoke about previously. But there also is a waiver available to non-immigrant applicants, non-immigrant visa applicants. And with that waiver, you would have to show, it's not as compelling as the provisional waiver, but you'd have to show reasons, explain why you violated the immigration law in the past, and why you benefit, or why you're not going to be a national security or a risk to the nation if they were allow you to come back in.
Now, other than family or asylum, are there any other ways that people can remain in the U.S.?
Yes, employment or business opportunities. If you're an investor from a foreign country, depending on your country's status, if there's a treaty between you and the United States, you may file for an E-2. If not, if you have a business abroad and you choose to come and open up a subsidiary for your foreign parent company and bring an executive over, that may be an option for you, known as the L-1. Also, if you're an investor and you're looking to become a permanent resident, there's the EB-5, which is a minimum requirement of $500,000 to $1 million to help support jobs here in the United States. That's an option for certain people. And lastly, there's also a slew of non-immigrant visas for employment purposes, such as the H-1Bs, temporary visas for temporary workers, and such.
Very interested. Thank you very much. Unfortunately, our time is up, and we thank you for tuning in. I want to thank Melissa McGuire-Mañao and attorney Jorge Sevilla for their participation in Conozca Sus Derechos. The Hispanic Bar Association of Central Florida is dedicated to community service, and in our upcoming episodes, we will continue to discuss important legal matters to the community at large. We wish to thank Orange TV for their assistance in bringing you this program. For further information, please visit hbacf.com. Thank you for tuning in.